What happens if DCPP decides to close the case?
When DCPP investigates a matter of child abuse and neglect, at some point in time, they're going to close out their case. That does not mean, however, that they're going to close out all contact with you. So the investigation could yield a finding of something other than substantiated, meaning they think something happened. It could have risen to the level of child abuse and neglect, but it wasn't of such nature that it met the legal definition of child abuse and neglect, so there is a child abuse finding against you. They could say in that instance they're going to close out their investigation, but they want you to do certain things in order to make sure that whatever the allegation was, that the problem doesn't resurface in the future, that it doesn't present an ongoing risk of harm to a child. If the agency says they want you to cooperate with certain services as a condition of closing out its case, it typically is going to require that you start that process before it closes things out. Now, once it decides to close things out, that doesn't mean that the agency never sees you again. Usually they're going to make a couple of visits after the closure of the case just to make sure that nothing has resurfaced and just to make sure that everything is going well. But normally, after the case is closed, if you choose to deny them access and everything is otherwise positive, if you're getting positive reports from service providers, if third parties with contact with your child are reporting that your child is doing well, many times the agency will simply elect to go away because they have no further concerns. But it's super important that you consult a DCPP attorney before making the decision whether or not to terminate your access or allowing access by the agency to your child or to your home, because many times denying access after they've closed the case may prompt them to reopen it.